A type of evil that the law was meant to constrain. That is part of the 29-page ruling that was issued late Friday by Sangamon County Judge Raylene Grishow about mask exclusion, vaccine, and testing mandates at schools on children and teachers and staff. That ruling coming out late Friday and a lot of back and forth over the weekend with school districts scrambling to find out what it meant for them. Also, the governor trying to get an emergency appeal and a stay. Have yet to see that transpire, but definitely will make for a fascinating couple of legal maneuverings that are going to be happening over the next few days, if not weeks. But what does all this mean? Joining us right now is the attorney who brought the challenges against the governor's mandates. One challenge, 700 plus parents against 145 school districts, the governor and state education officials. Another one dealing with vaccine and testing requirements for school staff against 22 school districts, the governor and others. So all of those seem to be on hold now. Those mandates, those requirements that your kids be forced to wear a mask in school or be excluded from school for possibly being in contact with a COVID-19 positive case. Also, the vaccine and testing mandates for certain staff as well being blocked. But what does this mean for the larger population? Is it just for those students who are impacted by the lawsuit? Is it just for those staff that are impacted by the lawsuit? Or did the judge striking this null and void essentially mean that, as she said in her ruling, all the districts now can govern themselves accordingly? To talk more about this in some detail and to find out how this is going to transpire over the next few days, Attorney Thomas DeVore bringing that case. He joins me now on the WMAY morning newsfeed. I'm Greg Bishop. Tom, thanks for taking time with us this morning. How you doing?
I'm well, sir. How are you?
Not too shabby. So let's go ahead and get into this. We've got the case that was decided late Friday. What are you finding out from your clientele as to how they're going to be approaching this starting today?
Well, again, there's a lot of moving parts to this, Greg. I think what's important first and foremost to start talking about is that there's 146 school districts in let's call it the parent case, and 21 in the teacher case, but there's an overlap, and there's only 2 extra school districts in the teacher case that aren't already in the parent case. So there's 148 total involved in those 2 cases combined. And over the course of 2 days, Greg, from Friday at 5 o'clock until yesterday when we all went to bed, our count has us pushing 200 school districts across the state that went fully mask optional district-wide, which is not required by the court's order, certainly for school districts that aren't in this lawsuit. And over, again, we're pushing 200 of them. I think that's the conversation, one of the conversations, because that's, the governor's marginalizing my client's position to the fringe minority has just been completely destroyed over the last 2 days.
So what does this mean, though, when it comes to those districts that are still going to have mask mandates in place? Because we do have those districts, including the Chicago School District and several others, who've said that they're going to still require masks. Are they violating the judge's order here?
Technically, they are not. Again, this is an interlocutory order. It's a temporary order. Her language is very strong, and I think that's why a lot of them relied upon that language in making their decision. So they're not violating her order as it exists today. But what they are doing, Greg, and what their lawyers have been telling them all weekend, which is why you've got 200 school districts, give or take, that have went fully mask optional, no vaccine testing program. What they're telling them is that Judge Grishow's order, if it carries the day and it remains the law through the appellate court, that what they're doing right now, even though it doesn't violate her order, it could end up being illegal and a violation of people's civil rights, because you now are knowingly doing something that she says is a due process violation. And if they continue to do that and that remains to be the law, they could be exposing themselves to pretty significant civil rights claims. And so that's why a lot of these school districts are switching to mask optional, and they probably think that's the best policy for their district anyway.
And let's just, reiterate, mask optional means masks can still be worn if the teacher chooses, if the parent of the student chooses to have their kids go to school wearing a mask, that's still allowed. And the judge also in the ruling Friday, Tom, said that you can also require masks if you have due process. One thing, Tom, one thing I found interesting is just the vast number of people who on social media seeing all of this news, they don't necessarily understand what due process is all about. You and I have talked about this practically every time I've had you on. Encapsulate for us what exactly this due process is.
What it means, and again, it's the way that the law is written today, Greg. Due process is twofold. It's one, what does the law say today? And if what the law says today is not adequate, there's another due process that says the legislature can change that, okay? And so the due process in the context of what the law says today is that if an individual citizen is going to be required to wear a mask, or they're going to be excluded from a particular building like a school, and they don't think that that is necessary in order to protect the public health because they're not a health risk, they have a right to object. And that due process means that they can go to court, they can have the judge decide whether or not this governing body is acting accordingly and properly. That's all we've ever been talking about is that due process. And the governor's been trying to take that away from people, which is one of the few things I think the judge was talking about when she made her evil comment.
We're talking with Attorney Thomas DeVore. He brought the lawsuits on behalf of parents and staff suing the governor and a bunch of school districts over mask mandates and vaccine or testing requirements, and a lot of questions for school districts to deal with as they approach all of this. But of course, the governor over the weekend filing an emergency appeal, saying the grave consequence from the misguided decision. Tom, I'm reading to you here his quote. He said, the grave consequence of this misguided decision is that schools and the districts no longer have sufficient tools to keep students safe during COVID-19, and it threatens communities, he said. This shows yet again that mask mandates and school exclusion protocols are essential tools to keep schools open and safe. We've had school districts have mask mandates or mask optional policies all school year, Tom. Have they had significant problems?
Zero. There's a few things I'd like to pull out of there, Greg, please. One, more of the conjecture and the more of the political propaganda of the governor. There is no such thing, and listen closely, there is no such thing as an expedited appeal of a temporary restraining order. It does not exist in the law. An appeal of a restraining order has a timeline, and it happens pretty quick, but you don't call it an expedited. He's saying that to try to get people whirling about, I'm going to be an expedited appeal. It doesn't exist in the law. But as to your next question, yes, I have school districts that have been mask optional all year, Greg, all year. And their positivity rates are no different than the rest of the state. And that's important because I want people to watch. And I said it yesterday. Watch what happens over the course of the next week or two, assuming that these school districts stay mask optional. In my opinion, you're not going to see surges in positivity across the state and the school districts. If we see that, we'll talk about what we think the legislature should do. But when the governor says we're taking away the tools, he doesn't get to decide what the tools are, Greg. That's the whole problem. The legislature decides what the tools are, and the law that I said applies and the governor or that Judge Grishow agrees, those are the tools that the legislature created. And if they're not adequate and they're not sufficient, they change it. He doesn't get to ignore it and create fiat that he thinks is necessary. That's what this whole case is about.
Attorney Thomas DeVore with us. A few other things here definitely need to get to. If you have a client who has a kid told by a school district they have to wear a mask or be kept from school, or if you have a client who has a kid that's told to keep from coming to school because they were around a suspected COVID-19 positive case, what's the process there for holding the school accountable?
And I've seen the correspondence from almost every school district that I was busy yesterday, and they're all going to respect my clients. I've only got one school district that's trying to be coy, and that's the Chicago Public School District, of course. And I'm going to file a contempt against them. But in general, if they do anything like that to my client, I'm going to seek a contempt violation with the judge against not only the Board of Education, but whatever principal or superintendent is trying to do that. And so I'm going to file that this morning against the Chicago Public School District because they're inappropriately and trying to be, I think it's in bad faith, to be honest with you, saying that it doesn't apply to them, and that it's ridiculous. But any other school district that wants to try to play that game, and I don't think they will because I've seen the correspondence from the other 140 something, I'll do the same thing.
Tom, what about all of those parents? And I'm sure you've got tons of emails and messages via social media who want to join this case or do another case. What's the status of the Parent 2 case and any other future cases stemming from all of this?
That's a good question. The Parent 2 case, Greg, I started laughing last night. The Attorney General, on behalf of the governor, filed a motion for substitution of Judge Grishal. These guys have no shame whatsoever. Their political gamesmanship, they don't even hide it. So we'll worry about that in a little bit. But as far as Parent Case 2, we'll see what happens with this appeal. This appeal may remedy all of this, Greg. But I could probably, if I wanted to right now, I could get another 200 or 300 school districts, parent groups from school districts across this state, and file a third parent case. But I'm not going to do that, because it's not necessary today. We're going to wait and see what the appellate court says about all of this, and they may put an end to it. And I think it's important to say, too, regardless of the appellate court and the TRO and that stuff, if these school districts will just continue to do what they're doing, this is all over with anyway, Greg, because think about all of these school districts that almost 200 of them went mask optional, no vaccine or testing policies district-wide. There's no court order requiring them to do that. But yet they're doing it anyway. So if they'll just keep that courage, Morton and them up north that are saying, we're done with all of this, we're going to go after ISB because we don't think you can do this. If our school districts will just stay the course like they've started this weekend, this is all over regardless of the court case.
Tom, something else, too, is the governor's executive orders, most recent 30-day disaster proclamation expired Sunday. I just pulled up his website where he has all these listed, and I don't see a new one. Do you have any indication that he's filed a new order that, and if he does file another order that says masks are required in schools, what does that ultimately mean?
Well, he did file, Greg. I haven't seen and you're right, they're not on the website because I think they're scrambling. I saw an article from John Kerr up north, The Emperor Has No Clothes. I thought it was kind of funny. But they're scrambling, so it's not on the website, but I do have a copy of Executive Order 2022-005. I don't have a copy of the disaster proclamation. And he issued that executive order, Greg, reissuing all of his prior orders as he does for the ones that we're talking about today. He issued that about an hour before, the best I can tell, the judge issued the ruling. But it's still invalid according to her ruling. It doesn't mean anything. But as to the disaster proclamations, you're right. And I'm thinking about, regardless of what we're dealing with now, I've got several clients and I've got a ton of lawyers across the state who all of a sudden want to join in, which is great. I think we're going to bring an action on these disaster proclamations because the courts have started to talk about and people are seeing he's just changing the numbers and reissuing these things. It's crystal clear now that he's just playing this serial proclamation thing into the ground. And I think he's completely disregarding the deference that the appellate court in the Foxfire case gave to him. I mean, he's not even pretending anymore. He just changes the number of cases and continues to rule with these disaster proclamations. We're going to bring that to an end, too.
Attorney Thomas DeVore, greatly appreciate you taking the time with us, and I'm sure you're going to be pretty busy over the next few daws, if not months. So we'll definitely stay in touch and find out what the latest is. All right, be safe out there.
Call me anytime, sir. Have a good day, Greg.
You too. It is the WMAY Morning News.